Welcome to the Canadian Charity Law Podcast, where we tackle the sometimes head-scratching world of charity law in Canada, so you can focus on the heartwarming stuff. Brought to you by the bright minds at B.I.G Charity Law Group, the charity lawyers who believe navigating regulations shouldn't feel like a complicated puzzle. We'll shine a light on everything from getting registered to smart fundraising and happy governance. Whether you're just starting out, looking to start a charity, nonprofit, or foundation, or looking to level up your charity game, we're here to bring clarity and maybe a chuckle or two. Ready to make an impact without the legal headaches? Let's jump in.
When you contribute to a Canadian charity, well, there's this underlying assumption that things are being handled properly, right? That your donation is actually making the difference it's supposed to. But what many might not realize is the really intricate web of rules and regulations governing these organizations. It's all about ensuring that trust is, well placed.
Yeah, absolutely.
So today we're doing a deep dive into the obligations Canadian registered charities face and, maybe more importantly, what happens when those obligations aren't met.
Exactly. And we're drawing on insights from Dov Goldberg and the team at B.I.G Charity Law Group. They've laid out a really valuable overview of Canadian charity law. It's crucial stuff for anyone involved or, frankly, just supporting these organizations.
Yeah.
Understanding this framework, it really helps everyone appreciate the responsibilities that come with that charitable status.
So our goal today is pretty straightforward. We want to give you a clear picture of what registered Canadian charities need to do to stay compliant with the Canada Revenue Agency, the CRA, and what the potential repercussions are if they slip up. Some of these rules might actually surprise you, and the consequences of falling out of compliance, well, they can be significant. They impact the whole charitable sector, really. So maybe to kick things off, what does it actually mean for an organization to be a registered charity in Canada? And why is keeping that registration so critical?
Okay, yeah. Being a registered charity in Canada, recognized by the CRA, it carries significant weight. It grants the ability to issue official donation receipts.
Right.
And as most people know, those give donors tax benefits. This is, a huge driver for charitable giving. It often forms the very backbone of a charity's fundraising and public support.
So it's way more than just a label. It actually unlocks vital tools for them to operate.
Precisely. And it's really crucial to understand that this ability, it comes with a pretty serious set of ongoing obligations. It's not like a one-time application thing. It's a continuous commitment.
Okay.
The fundamental point to grasp, really, is that failure to meet these obligations can lead to penalties and, in the most severe cases, even the revocation of their charitable status.
And as our source material emphasizes, that loss can be devastating. Just the inability to issue donation receipts, that alone could cripple fundraising. Plus, the damage to how the public sees the organization must be immense. It really makes you wonder about their long-term viability beyond just the immediate financial hit.
Absolutely. I mean, the inability to offer tax receipts can significantly deter potential donors. But beyond that, revocation, it sends this really strong negative signal about the organization's management, its adherence to regulations. It makes it incredibly challenging to regain public confidence and, continue their mission effectively.
Okay, so the stakes are clearly very high. But the CRA doesn't just immediately jump to the sort of nuclear option for every minor oversight, right? The source talks about a graduated scale of enforcement. Can you maybe walk us through how that works?
Yes, that's right. The CRA's Charities Directorate, they take a considered approach. They understand that instances of noncompliance vary, in nature and severity. Their response generally follows a kind of four-stage model, starting with education.
Okay, that sounds pretty proactive, like a supportive first step. What does that actually involve?
Well, this initial stage often involves the CRA reaching out to provide guidance, maybe clarify regulations, and essentially help the charity understand how to correct whatever issues they've identified. It really underscores the CRA's intention, which is generally to help charities operate successfully within the rules. This can be particularly helpful for, say, newer charities as they're navigating all the complexities of the regulatory environment for the first time. They might get specific advice on setting up their financial reporting correctly or understanding the nuances of what counts as an eligible charitable activity.
So it's about getting them on the right track, hopefully early on. But what happens if the issues are, more serious, or they continue despite this guidance.
Yeah.
That's where compliance agreements come in, I understand.
Correct, yeah. If education isn't enough, or maybe if the initial noncompliance is just more significant, the CRA might look to enter into a compliance agreement with the charity. Now, this is a formal, legally binding document.
Okay, formal. Binding.
Yes. It outlines the specific issues, the steps the charity absolutely must take to resolve them, agreed upon timelines for those actions, and crucially, the potential consequences if the charity fails to meet these terms.
So it sounds like a real chance for the charity to show, okay, we're committed to fixing this.
Exactly. It's a structured plan for improvement, but it's vital to recognize the seriousness of this formal commitment. Failure to stick to a compliance agreement significantly bumps up the likelihood of moving to the next, more severe stage, sanctions.
Yeah.
And this is also a point where, frankly, having expert legal counsel can be invaluable. They can help charities understand the agreement's implications and make sure they can realistically meet its requirements.
Okay, so education and compliance agreements are about correction. Then we get to sanctions. What kind of penalties can the CRA actually impose at this stage?
Right. Sanctions are the measures the CRA can take when those earlier stages haven't worked, or maybe for more serious initial problems. As the source material points out, these are really intended to deter future noncompliance and ensure accountability across the sector. One primary form of sanction is financial penalties. These can vary quite a bit, depending on the nature and the extent of the noncompliance.
So it's not like a standard fine for everything.
No, definitely not. The calculation can actually be quite intricate. It takes into account factors like, the degree of noncompliance, its impact on the charity's operations, or maybe the impact on the public. These financial penalties can place a significant burden on a charity's resources, potentially hindering their ability to actually deliver on their charitable mission.
Yeah, I can see that.
Yeah.
Especially for organizations often running on tight budgets. And then there's the suspension of the right to issue official donation receipts. That sounds particularly damaging. Why is that such a critical sanction?
Well, as we touched on earlier, that ability to provide tax receipts is just a cornerstone of charitable fundraising in Canada.
Totally.
If this right is suspended, even just temporarily, it can have a profound negative impact. Donors often rely on those receipts for their own tax benefits, right? So they might be unwilling to donate if they can't get one. This directly hits the charity's financial viability, and it can severely erode public trust. It might even lead donors to question the fundamental legitimacy of the organization itself.
Wow. Yeah, that's a very visible consequence for donors. Okay, so if these measures still aren't enough, or if the noncompliance is just really severe from the get-go, we reach the final stage, revocation. This is the ultimate loss of charitable status, right?
Exactly. Revocation is the most serious consequence. It's the complete loss of registered charity status, and it comes with significant and, frankly, lasting implications.
Okay, let's break down what that actually entails. We've already talked about losing the ability to issue donation receipts. Huge blow. But what other tax benefits are lost?
Right. So, beyond the donation receipts, the charity itself can lose its tax-exempt status.
Oh, wow.
Yeah. This means the organization could actually become subject to corporate income tax on its income, which fundamentally alters its entire financial structure and obligations.
So their income could suddenly be taxed like a regular business. That's a massive shift in their financial reality. What happens next? The source mentions asset dispersal. What's that about?
Yes, this is a really crucial requirement. When a charity's registration is revoked, they are generally required to transfer their remaining assets, whatever they have left, to another qualified demopo. Meaning another registered charity or a similar organization that's eligible to receive such funds. There are specific regulations governing this whole process, and it often needs legal guidance to make sure it's handled correctly and in compliance with the CRA's requirements.
Okay, so the resources intended for charitable work still kind of stay within the sector, which makes sense. But what about the impact on the revoked charity's reputation and the public trust they've probably spent years building?
Well, revocation carries a significant stigma. It severely damages the organization's reputation and can lead to a substantial loss of public trust. And that can be incredibly difficult, sometimes impossible to repair.
Yeah.
Fundraising efforts will likely be severely hampered, volunteer recruitment probably suffers, and overall community support might just, dwindle away.
It paints a really challenging picture for their future. Can they even continue to operate in any meaningful way after revocation?
Operating without registered charity status presents just huge hurdles. Their access to funding is greatly restricted. The legal and tax landscape changes dramatically for them. They would likely need to undergo a really significant restructuring just to continue pursuing their mission, maybe in a different legal form. It's a fundamental transformation of how they can function.
This all just really underscores how important it is to stay compliant in the first place. What are some of the key preventative measures charities should be focusing on?
Proactive compliance is absolutely essential. The source highlights several key areas that really demand ongoing attention. This includes the accurate and timely filing of their annual information returns. That's Form T3010.
Right, that T3010.
Yeah, that gives the CRA crucial information about their activities, their finances. They also have to strictly adhere to spending rules, making sure their resources are actually directed towards charitable purposes and that they meet the required disbursement quota.
The disbursement quota. That's basically the minimum they have to spend on their charitable work each year.
Exactly. It ensures funds are actively being used for their stated mission.
Okay. What else is critical?
Maintaining proper records is paramount. Charities need meticulous financial records, accurate documentation of donor information. It's all about demonstrating accountability and compliance. Strong governance and transparency are also key. This means having well-defined organizational structures, clear policies, and just operating in a way that builds and maintains public confidence. And perhaps most importantly, charities have got to stay informed about the constantly evolving legal requirements and guidelines. It's a dynamic area of law. It changes.
So it's not a static set of rules. Charities need to be proactive, constantly staying up to date. And this sounds like exactly where the expertise of a charity lawyer could be so valuable, isn't it?
Absolutely. A knowledgeable charity lawyer can provide just invaluable guidance in navigating this whole complex regulatory landscape. Their involvement can start right at the beginning, helping with the initial charity registration process to ensure it's accurate and meets all the CRA's requirements.
Okay.
But they also offer ongoing advice on all sorts of compliance aspects, from financial reporting obligations, understanding fundraising regulations, ensuring proper donor receipting practices, to implementing sound governance policies. For instance, they can advise on whether, say, a specific fundraising event complies with the rules around issuing eligible gift receipts.
So they really act as a guide through all the legal complexities. What other ways can a charity lawyer provide support?
Well, if a charity finds itself facing CRA inquiries or audits, a lawyer can represent them, help navigate that process, and potentially mitigate any adverse outcomes.
That sounds crucial.
Yeah. They can also assist in drafting and reviewing internal policies to make sure they align with charitable regulations. For big organizational changes like amalgamations or maybe even dissolving the charity, they provide critical legal counsel to ensure compliance, especially with those rules about transferring assets we talked about.
Right.
And, in the unfortunate event of actual compliance disputes, penalty assessments, or even revocation proceedings, a charity lawyer can advocate strongly on behalf of the organization.
It really sounds like having strong legal counsel can be a critical asset.
Yeah.
It helps charities avoid potentially serious problems and allows them to just, focus on their core mission.
Precisely. Operating as a registered charity, at the end of the day, it's a privilege, and it comes with significant responsibilities. The CRA has a system in place to ensure these responsibilities are met. And while their approach is graduated, the consequences of non-compliance, as we've seen, can be severe. Proactive compliance, often supported by the expertise of a charity lawyer, enabled organizations to navigate the regulatory framework with confidence and just continue to make a positive impact without that constant risk of jeopardizing their status.
So the key message seems really clear.
Yeah.
A thorough understanding of and consistent adherence to CRA obligations is just paramount for Canadian registered charities. It's about more than just following rules. It's about upholding the trust placed in them and ensuring their long-term ability to contribute meaningfully to society.
Exactly. And it kind of prompts us to consider, that the dedication and effort within the charitable sector, combined with the trust from donors like you, makes this framework of accountability really essential for maintaining the integrity and the long-term health of the entire Canadian charitable landscape.
So, if you're involved with a Canadian charity, or perhaps you're considering making a donation, we hope this deep dive has provided some valuable clarity. For more in-depth information, we definitely encourage you to explore the resources offered by B.I.G Charity Law Group, whose expertise really informed our discussion today.
Their insights can offer even further understanding of this vital area.
Absolutely. Ultimately, informed engagement strengthens the charitable sector. allowing these important organizations.
Thanks for spending some quality time with the Canadian Charity Law Podcast. Brought to you with a smile by the team at B.I.G Charity Law Group. We're genuinely excited about the amazing work you do and are here to make the legal side of things a breeze, or at least a gentle breeze. If you're looking for legal guidance that's both insightful and approachable, swing by charitylawgroup.ca. Discover how our positive attitude and deep knowledge can help your organization thrive and make an even bigger difference. Don't let legalities dim your charitable sparkle. Connect with the cheerful experts at B.I.G Charity Law Group at charitylawgroup.ca. We promise it won't be taxing. See you next time.